All right, so this is a conversation I'm having. Check this out. All right, so yesterday I'm trying to figure out how I'm gonna write this letter or how I'm gonna write this bar grievance against the lawyer. So I'm like, I need to brushing up on the rules of evidence, Texas rules of evidence. I got to look at this shit again. So I grabbed the iPad and I'm scrolling, and this hit me for a loop. It's Texas Rule 501, privileges in general. It says, unless a constitution, a statute, or these or other rules prescribed under statutory authority provide otherwise, no person has a privilege to A, refuse to be a witness, refuse to disclose any matter, refuse to produce any object or writing, or prevent another from being a witness, disclosing any matter, or producing any object or writing. Period. Texas Rules of Evidence 501.
Okay.
Now, you go.
Explain that.
Okay, hold on. I'm gonna come right back to this, but I'm gonna jump back to your Fifth Amendment right. Everybody know to plead the Fifth. That's the basic one. Everybody know that one. Yeah, I ain't got the right to incriminate myself.
Mm-hmm.
Hale versus Hinkle, good one. You ain't gotta incriminate yourself.
Mm-hmm.
So we know that to be true. So how can they make this statement right here? It said, let's read it again. It says, unless a constitution. All right, so now we got constitution. Okay, so at least I can get to the Constitution, and we know freedom of speech. I got the Fourth Amendment right, so you know you can't search me, you can't touch me. All right, at least I got those. But hold on, wait a minute. Now I can use a statute. Okay, they might got a couple of those. You know, 104 something. All right, so here we go. These other rules required under statutory authority. Otherwise, now statutory authority. What is that? That's something that's new to you. Because you know common law or the law of the land or just the law. That's what they wrote about in the Constitution. The law of the land. Statutory just come out of nowhere. But statutory really is rules and policies for the government. Meaning that if I'm in that club, I gotta follow these rules. And those rules would be called statutory rules.
So that's specifically towards people
In that club only. That's who they're talking to. It says unless
and
you got
that's a statutory law.
that statutory realm, that statutory law, that was statutes for the statues, you know, at the Queen's Palace, those statues, that's who they're talking to. So now we read it and say, okay, no person has a privilege to refuse to be a witness. All right, yeah, that makes sense now. Buddy at the gate, if I work for the government, can I refuse to be a witness?
They do.
We ain't talking about what they do, we talking about what we read. And so it says, we can't refuse to disclose any matter. These are persons. But this is all in context into evidence of a trial. This is what this is based upon. This is court proceedings. This ain't in the street. So this is what he's talking about. But it says in court they got to produce all this shit. But they're not talking to you, because if they were talking to you, you got the Constitution on your side, and therefore you can use that as a privilege, which is your rights. They changed your rights into privileges. You see what I'm saying? You see that clean, the little trick word. So now we talking about privileges. We know privileges is right by their definition. So let's keep scrolling and see something else that's kind of caught my eye. So I'll read, that's 501. Then we go up to 512. 512 is privilege matters disclosed under compulsion or without opportunity to claim privilege. A privilege claim is not defeated by a disclosure that was A, compelled erroneously, or made without opportunity to claim the privilege. That's a good thing. That means if I fucked up and didn't say I got the Fourth Amendment right, you didn't have, I got the privilege by their rules, but actually this ain't talking to me. They still not talking to me. Only if I'm playing in the club are they talking to me. But it's a privilege. If I'm the one they talking to, if we're gonna play that game like I'm the one they talking, all right, cool, we got the privilege to bring up this matter. But something happened. The very next one, it says 513, it says comments on or inference from a privileged claim. Instructions. Who to? We talking about evidence. We talking about court. Now we gotta be talking to the judge now. We talking to the judge. That's how I'm talking to you. Comments or inference. Inference is having any opinion. You can't have nothing. It is what it is. Not permitted. Except as permitted in Rule 504B2. That's talking about spousal disclosure and stuff like that. So that's not what we got going on. Yeah, spousal stuff. Your spouse might have to testify if you on your side. If you tell her to testify, she got to testify. That's what that's talking about. But yeah. So neither the court nor counsel may comment on a privilege claim. Neither the court nor counsel may comment on a privilege claim, whether made in the present proceeding or previously, and the fact finder may not draw an inference from the claim. That sounds good. That sounds good. It kind of sounds like he got to do his job, but hold on. Claiming privilege without jury's knowledge. To the extent practical, the court must conduct a jury trial so that the making of a privilege claim is not suggested to the jury by any means. Now let's replace privilege with the word right. Claiming a right without the jury's knowledge. To the extent practical, the court must conduct a jury trial so that making of a claim of right is not suggested to the jury by any means. What?
You're lost.
I lost you. Where did you get lost? Is it because the court can't say nothing? Or the court can't allow the jury to know about the privilege claim?
What? Are they supposed to know everything to be able to decide guilt or innocence?
You would think that would be fair.
It's like withholding evidence.
If I claim the right under the Constitution, they're saying in court I can't claim that right in front of the jury. That's what they're saying. The claim of privilege against self-incrimination in a criminal case. It even goes any further what we're talking about. What these rights, I'm not confused, self-incrimination. Subdivision A and B do not apply to a party claiming in the present civil case of the privilege against self-incrimination. Jury instructions. When this rule forbids a jury from drawing an inference from a privilege claim, the court must, on request of a party against whom the jury might draw the inference, instruct the jury accordingly. So that means you got to do that yourself. That's what they just said. A party against whom the jury might draw an inference, instruct the jury accordingly. So what? Okay. So why that don't make sense? Now I'm gonna show you why that makes sense, because it's gonna fuck you up. Here you go. This is why it makes sense. It says equality under law. Equality. This is the Texas Bill of Rights, Section 3A. Equality under rights. Equality under the law shall not be denied or abridged because of sex, race, color, creed, or national origin. Period. This amendment is self-operative. Play with these people y'all want to, man.